Good afternoon.
Good afternoon.
How's everyone?
I'm fantastic.
Fine. Oh, fun. Oh, wonderful. That is nice to hear. Okay.
How you doing, Miss Archer?
I am fine. What about you?
Well, I'm the one who's fantastic.
Oh, well, don't say that. You're gonna be fine. You saw the email I sent with 2 attachments?
Yes, I did see it. Yes,
Three attachments. Because I attached the
You sent it.
yes, I sent it.
Good afternoon. Sorry, everyone. Good afternoon.
Good afternoon. Yes, I did. Who is that speaking? Tony? Hold on.
I see no email today.
Yes, this afternoon.
My kids are not working.
Hold on. Let me go to my sent box. Let me see if you're in my email. And 3 more. No, what's your, hold on. Your email isn't on this thing. Hold on, Tony, hold on, let me get my paper. That's my list of attendees.
Miss Archer, you forget me?
No, I have a TI looking to see, no, it here. It went to your work email.
I get nothing today.
Yeah. Look
What time
again.
is it?
Let me see. No one got it?
I didn't get anything from you today.
Good evening, everyone. I got the emails, Ms. Archer.
Okay,
Good evening.
I know I sent it.
now that I'm looking, the email I got actually came from Miguel.
I had copied Miguel, just in case.
Okay, so yeah, I got it then.
Yeah, okay. You still don't have it, Tony?
I bring.
Not at all, you don't have it?
No, I ain't got nothing from you today.
Well, what is this? THETIS. Aha, I see. Hold on. Tell me what it is. TIS.
No. TSIMMONS.
Ah, that's me.
Okay. At the gdccu.org.
Okay. Hold on. I'm about to send it to you right now. That's me.
Okay.
GDCCU.
Yes.
ORG. Okay, let's do this right now. And you could tell me you have it.
Okay.
Why spell your name wrong?
I know.
I think that's the same thing happened last night. Remember when you said you didn't have it?
Yeah.
Yeah. Okay, tell me if you have it now.
I'm pressing it right now.
You should have it.
Nothing yet.
What you mean?
Well, you're not here. The last thing I got on here is at 4:15 today. I'm gonna know that.
TSIMMONS at THEGBCCU.org.
Yes.
Yeah, well, that's where I sent it.
Emails up and open. Okay, now
608.
it came through.
Ah, okay. No, it
Okay.
can't be that bad.
Thank you very much.
Okay, finally. Okay, I have another case. Let me see if this one is worth sending. We're gonna start off with, before we begin, laws relating to mortgages. Let's look at, let's see, which one is this one? Not that one. Let's go with the Bank of the Bahamas versus the Delavos. Have a look at that one first. Why does come out like this? It's come out funny. Oh, that was me, not you. Okay, so let's start with that one first, and then we will go through the chapter. This chapter is always on the final exam. I mean, everything is more or less cumulative, but this one is always on the final exam. I printed things the way it wanted to. 7, 8, 9. Okay, gotcha. And whoever finished reading first, let me hear your take on this one. I'm sorry, this is a BOB case. My apologies. for
Which
those
one
from
are we
BOB.
doing again, Miss Archer?
We're doing BOB and the Delavos.
Okay, thanks.
Miss Archer, I still don't think I have the email. You have 2 new students, right?
Oh, Mr. Pratt didn't send it to you?
No, ma'am, just
Okay. Hold on. Let me get your email. Give me yours, Hepburn.
my first and last name at yahoo.com.
Oh, the full thing.
Yes, ma'am.
Okay, Brianne Hepburn
Yes, ma'am.
at hotmail.com.
Yahoo.com.
Oh, Yahoo, okay.
Okay, thank you.
And Ellsworth? He's on BRY.
Hello,
Yes,
hello.
what's your email? Okay, Brian, yours is there.
Thank you
You
so
should
much.
have it. Okay. Now let me see if I can find Ellsworth email. I know Miguel sent something earlier. Let me see if I can find his own. Because he'll be missing the cases too.
Hi, good evening, Ms. Archer.
Yes.
This is Anika Maki. I'm just joining tonight for the first time as well. I did get some items from Miguel today, so I just want to make sure the clients are Christensen and Marilyn Delaval. That's the case study we're looking at.
Yes.
Okay.
And then the next one after that will be Butler, Bahamas Development Bank, and Butler and Roll.
Okay, I don't think I have anything. I don't recall
You have
seeing anything.
those?
I don't recall seeing anything for Bahamas Development Bank.
No, speaker, I can't hear you.
I said, I don't recall seeing anything for Bahamas Development Bank.
Okay. N. Johnson and who's N. Johnson and Associate? I don't know that one.
That's me.
Oh,
I
that's
prefer-
you.
Yeah. Can you send it
All
to ellsworth.johnson@gmail.com, please?
Ellsworth,
Dot
L.
Johnson,
Johnson,
no, Ellsworth, dot, like a full
Johnson.
stop,
Mhm.
Johnson@gmail.com.
Okay, all right, I will. I'll do that right now.
Okay.
And the other one who just joined, what's your email? Because I'm looking at you're Anika.
Yes, ma'am. I sent a message to you in the chat with the email address.
Okay. Bank of the Bahamas?
Yes, ma'am. That's correct.
Okay, okay, all right. I'm gonna send it to you now. Sent. Go to here. Forward and Ellsworth. Johnson. gmail.com. And come on. Okay, you should have it.
Okay, thank you.
All right, not a problem. Are you as far as paragraph 7? With the discrepancies? Anika, you must be familiar with these systems.
Pardon me?
Are you familiar with these systems?
Which systems are you referring to?
Paragraph 11.
I haven't gotten theirs yet.
Okay, all right, I'll wait till you get there.
Yes, ma'am.
Okay.
Hi, Ms. Archer.
Yes,
Okay, just one of them I'm familiar with. I'm still a little new to BOB.
oh, okay,
But
okay.
the flex cube system I'm familiar with. Or the FCS,
Mm-hmm.
yeah, I'm familiar with that one.
Yeah, the Flex Cube is the new one
Well, based on this,
at that time.
yeah, the appears that, yeah, it was in existence from then. I know they just did an upgrade to it, but it appears to have been in existence from 2007 at
Mhm.
least.
How far are we, Monique? How far are you?
I'm on page 13,
Oh, okay,
not at 16, item 16.
okay. Note paragraph 17.
Hi, good evening. This is Keishla. I'm just joining. Where are we?
We are reading the case of B.O.B. versus the Delavos.
Okay, thank you.
Okay. Okay, Brianne, you almost finished?
Yes, Ms. Archer, I'm finished reading the case.
Okay, all right. Keishal, I know you just started. So in essence, in a nutshell, okay, Brianne, you could start.
Why, thank you, Ms. Archer. I was just about to get there. Basically, the divorce mortgage is in arrears, and they brought this action to stay the writ of vacant possession because they highlighted some discrepancies on BOB's behalf. One being that there was a discrepancy in what was actually owed on the mortgage. I think that was the main discrepancy.
Yes,
Apparently, BOB was using two different systems, and one system would give you what was owed, what was currently owed, and the other system took a little while to update, so it wasn't as accurate. So that provided a discrepancy of in excess of 30 grand. And the divorce wanted a proper accounting as to what the judgment should actually be. There was also a discrepancy as it relates to the mortgage account number. Later in the case, an issue arose that after the case went to the Court of Appeal, an order was made that there were to be no costs. But in putting together what the divorce owed, they noted that legal fees were being tacked on. And that was particularly troublesome, that legal fees were tacked on after that order from the Court of Appeal. So what Winder said is that the divorce never contested that they did in fact owe BOB and that the mortgage was in fact in arrears. So he wasn't going to throw out the writ for vacant possession, but he was going to allow BOB an opportunity to provide that proper accounting, and BOB also needed to answer for why legal fees were being tacked on, contrary to that order of the court. So I think they got 90 days to put their house in order.
right. And if you notice from the cases that we looked at last night, you notice that the court normally gives at least 90 days on either side in order to get all of their ducks lined up in a row. Because we're noticing now that there is a common inconsistency with the balances that the bank is stating that the clients owe. This one now is due to a system. I just sent you another case. Look at the last one I just sent. Again, there is a discrepancy on the amount that is owed. That's the one that's called Bentec and FCIB. Here, the plaintiff again is saying that the figures are not correct. And I know from experience, even without a change in the system, sometimes you could have a glitch in the system, because I've known clients that have come in and have actually kept, like they would periodically request copies of their statements. And then when it's time for their loan to be paid out, there is a difference in the balances. And so this is another thing, as mortgage officers, you have to check. And I know some people don't do it unless the credit department actually sits down and does it. The back credit office sits down and actually goes through a person's mortgage from the beginning to the very end. to ensure that the balances are correct.
As the consumer, how do we guard against these kind of discrepancies?
The only way is one client that I saw when they came into the bank, like I said, they actually got a statement every year, at the end of every year. And that's how they reconcile their balances. Now I've known of others. Go ahead. What are you going to say, Tony?
I was going to ask, why do they have two accounts? Why do they have two separate account numbers?
Two separate systems.
For one mortgage?
That can happen too. That can happen too if when you move from one system to another system, that's a different accounting method. A different sequencing.
Okay.
And then again, this is another part that plays into it is the internal controls. When you transfer from one system to another system, someone's supposed to sit down and call it back and check and make sure it is accurate. And then you have to make sure that the system is calculated in the correct manner.
Yeah,
Otherwise,
maybe that's where they're came in too.
yeah, you're gonna have problems with balances. So in the one with Bentech, you say they actually had an auditing firm to review the accounts. And they had two facilities, one for 1.2 million and the other one was for 37,000. And the client believed that his funds that he was paying was not being applied against the loan. So he engaged an accountant and he found that there was a difference of $167,000 that was not accounted for. So he requested a historical amortization. And so the bank provided him with the history from the 14th of July, 2011 to 2017. But the company was still of the view that the loan payment history provided by the bank was an incomplete record of the loan. That's paragraph 8. As is accounts for the payments from 2011 and not 1994, when the initial mortgage commenced. So the bank said it was not required to retain the records in respect of the paid off ex-Barclays PLC loan from 1994. Because remember now, Barclays PLC, remember, was taken over by First Caribbean International Bank. And so you see, he said in paragraph 9, he asked again for a comprehensive review, and the bank responded stating that the records were the full history of the loan, as the previous loans had been closed when the new terms and conditions in the commitment letter took effect, and the documents were provided to the client, constituted the full history of the existing loan. And so they said the account had been closed more than 7 years and they were not required to retain these documents. But according to Baker Tilly, $167,000 was not accounted for. So then they asked for bank statements from 2017 to date. But the bank came back and said, we've already provided you with the statements. So the court said that Bantech, what they should have done is particularize their claim and the effect of what was produced in the statement of claim is that the bank is unable to put in a defense in this unorthodox statement of claim. And of course, the judge went on saying that the bank itself produced the reasons why the statements, one was paid off after the bank was sold. And they say that the business relationship in respect of those loans had ended more than 5 years ago. And thereby it would, so thereby they were in compliance with the FTRA. But the client maintained that none of the loans were satisfied. And so the documents which are being produced did not cover the entire period of the loan. The commitment letter in June 2011 may have incorporated the 94 and 2003 loans. And if the commitment letter did, then Bantech may have a very steep hill to climb given the provisions of the FTRA. The bank also said that Bantech's audit was inaccurate because the record period that they based the audit on was incomplete. And the bank was still insisting that the refinancing over the years and the commitment letter of June was really the starting point for Bantech's account. So the question was really whether the bank had breached its contractual obligations to Bantech, express or implied. So what the court concluded was that the statement of claim needs to be amended so that the bank may be able to put in a proper defense. Because all it did was just said, this is the amount, that's the difference. And it had to actually clarify a reasonable cause of action. Now, I haven't seen what happened after that, but they did ask them, Bantech, to send in an amended statement of claim. So this is another case where you see, again, there is a difference in the amount that the bank itself is claiming. One was a bank that was sold, and the other one was a change in systems. Both refer to internal controls. So let's go to our notes. We know that mortgage over land, once that loan is repaid and the land becomes free of the mortgage, then it's said that the mortgagor has redeemed the land. So during the currency of the mortgagor's residual rights in the land are known as the equity of redemption. And we spoke about that earlier. It's the value of the unencumbered collateral minus the value of the secured loan. Note that a mortgage and a charge are different in terms of the interest that occurs when they get a loan. A mortgage implies a transfer of the mortgagor's interest in the property as security. Because remember now, when you apply for funds and the bank takes out the security, which is the mortgage over the loan, recall now that that borrower has both a legal and an equitable interest in that property. And by executing the mortgage, the bank then takes the legal interest in that property. So a charge implies what we call a mere right to look to the charger's property to satisfy an obligation without such a transfer. There's no transfer of interest in a charge. So whenever you speak about security, there are two distinct issues that always come when you talk about security. One is, what is the nature of the interest in the land or the collateral itself? Whether you have the freehold or whether you have the leasehold interest in that land, or whether it's legal or equitable. And remember, we spoke about equitable before. It can be a person who is a beneficiary of a trust or someone who's occupying land for the duration of their life. So when a secured loan is obtained in relation to a mortgage, the mortgagor gives the mortgagee an interest over the land, and that's a right in priority to other creditors. It also gives you the power to obtain repayment of the loan, including any interest, through legal remedies, and that includes the power of sale. And remember, the power of sale is when the borrower is in default. Recall Section 22 of the CLPA. Enforcement of the mortgagee's rights through established and actionable legal remedies is a fundamental premise of the law relating to mortgages. The mortgagee is merely exercising its right to dispose of the land by sale so that it may repay itself what it owes under the mortgage loan. Notice in all of the examples that we have gone through from Unit 1, you notice what does the bank do? The bank or the insurance company or the mortgage corporation, the first thing they do is they say there is a debt. The debt is now due because you are in default. And then they ask for writ of possession. Note that any surplus obtained in the sale of the mortgage property belongs to the mortgagor, and that's subject to the rights of the mortgagee, to whom the mortgagor may have given subsequent mortgages to the same land. Because remember, I was telling you that if you have a piece of land, you may have a mortgage, and then you may actually have other loans attached to that same collateral. So even though they sell the home, they may decide, even though the others are in default, it depends on the arrangement that you make, that they want to just get rid of all of their debt. Or they may decide they don't want you no longer as a client. So the mortgage loan is a contract under which the mortgagor offers a legal interest or mortgage over his land. And in return, he gets a loan under which both parties undertake to carry out certain legal obligations, one of it being repayment of the loan with interest. So as you can see in the case that we did today, there was no argument from the Delavaux that they were in default. It was obvious they were in default. Not like the case that we did last night, where the husband and wife, the wife's payment was still coming out of her salary. The husband was not making his contribution, but they were not aware that their house was up for sale. And they continued to make the payments over the years, and also have discussion on restructuring the loan for overvising them, that they had a judgment order against them. So the mortgage acts as security for the mortgagor's due performance of the contract. Once the mortgagor performs his obligations under the terms of contract, his land is released from the mortgagee's rights or legal interest in the land, and is freed from his personal obligation to the mortgagee. If the mortgagor fails to discharge his obligations under the mortgage loan, for example, repaying his loan, or in the other case we did last night, where the borrower did not pay the maintenance fees on the condominiums, then the borrower is in breach of contract and may no longer retain his contractual right to redeem his security by payment at a later date. So recall in that one, she had already paid the mortgage, the principal and the interest, but she still had amount owing for the maintenance fees that the bank had paid on her behalf. And the judge said that is very sad to see that she had paid off her principal and interest, and she's about to lose her home because she did not pay her maintenance fees in the amount of $90,000 plus. However, under the equitable principle of the equity of redemption, the mortgagor has a right at any time after the contractual date of repayment to pay the loan and redeem his security. So now let me ask you, I knew of one client coming in to repay or redeem his security. And he actually wanted to redeem his securities 10 years in advance. What he had done was, as he paid the regular monthly payments, he made principal only payments. And the bank was giving him a very difficult time in paying off his loan. They said they were not willing to absorb the loss of the interest that he would not be paying for the 10 years. Anyone else had an experience like that?
Hello?
Yes, Ellsworth?
Yes, I've had a personal experience where I have a mortgage and I've been making principal payments directly to the principal. And I went in the other day only to discover that they weren't making the principal payments. They still had it on my account.
Now, I've seen that one too. And that's why I'm saying it's very important at the end of every year, you get a statement. Because you could have actually decided on your own that after X number of years, okay, my mortgage is finished. And then you come to realize that they haven't applied it at all. Then what do you do? Because the system has already accrued the interest. See, the thing is the bank doesn't want to lose that interest. It's already calculated that interest and its profits going forward. It knows exactly how much it's going to make at the end of every quarter, every year, based on the mortgages on the books. So one thing they don't want is for you to make principal payments. Because then you're cutting back on their profits. Anybody else?
As a consumer, you have to ask questions and also read fine print, because a lot of banks impose penalty for early repayment.
Yes,
within a certain specified period of time. So you really have to know, and it varies from institution to institution. So you have to really ask and be aware that that is, very possible, and know what it is that will be expected. Because when you sign that mortgage agreement, you literally sign and say, hey, I'm willing to pay you X amount for 30 years. And that is the agreement that's in place. So if you want to alter that agreement, you have to then, do it in a way where all parties concerned are aware that that is your intention also. Because then they will be able to tell you that, okay, if you want to do that, yes, that is an option for you. However, the penalty for that is X, Y, and Z, because we need to recoup some of our interest that we would be otherwise losing. And then everybody's on board with that. But of course, once again, in the beginning, everybody's just so happy that they're getting the loan. They don't care anything about anything else other than they sign on the dotted line. Some of them, even though you might tell them to read thoroughly what they're signing, all of a sudden everybody gets an Alzheimer's situation at a certain point.
Yes, but if the mortgage deeds that I have looked at, they don't mention the penalty for early retirement. For early redemption. So again, like you're saying, all of those papers that you sign, something has to be in there. If it's not in there, then you have to speak with the back office credit, saying that this is what you want to do, and they'll tell you how many years in advance you can actually pay down your mortgage. Because like you were saying, it has to be an agreement between the borrower and the lender, and it has to be mutually agreed that that is what you intend to do. Because like I said, they have already calculated that interest. And especially now that they're doing this reduced rate, they do not intend for you to pay your mortgage early. That's not the intention. The intention is for you to borrow for 25 to 30 years and to reborrow and reborrow and reborrow. That's the intention. And we talk about this in first class.
Part of the issue too is when that payment becomes applied to the account, it has to be clear as to exactly what the borrower's intention is, because there are multiple scenarios. If let's say it's a payment of, I don't know, $5,000, it's possible to pay that directly to principal, but it's also possible to apply it as though it's multiple payments going through. So the two different scenarios create two different situations, because when you present it as multiple payments going through, it will push your payment due date forward. However, if it's just applied to principal, it will reduce your principal. But what a lot of persons do not understand is that the following month, when it comes around again, interest is still calculated. Yes, it's on a reduced balance, but interest is still calculated. And then, life goes on as normal, as though, that payment, yeah, you made a little lump sum payment, but it's no, as far as the system is concerned, it may not, reflect the way the client wants it to reflect. Let me put it like that.
Yeah.
So it has to be made very clear to them.
Elsewhere, it's getting clearer.
Because depending on how it's applied, you may be saying, oh, I want to see my balance reduced by $5,000. And then you get your printout and you don't see that. But then what you don't realize, depending on how it's applied, it may have paid off some of the interest that was due, and then the rest would have gone to principal, but it wouldn't be the full 5,000. So it just depends on how it's done.
Yes. Yeah, I appreciate it. I'm having someone assist me with it, because believe it or not, I discovered that the loans officer couldn't properly explain to me how it was being applied. And then was this another crazy thing where you would pay at the counter and you ask that it be paid to your principal. They give you a receipt saying it's paid to your principal. And then they would say to you, I didn't realize this, that I had to leave the counter and go to the receptionist and tell the receptionist, who would take a photocopy and then give it to my, Jesus Christ. So, and then they would give it to my loans officer. And so it's really backwards. I'm in the process of moving my loan from that bank to go somewhere else. But before I do that, to have an independent person assess the payments, because what I said to the bank, I said, listen, if I gave you a lump sum payment on a certain date to apply to my principal, you should have done that. And then the requisite, everything that would fall in place in terms of the rebate or what I would get as an advantage to paying to the principal. But you don't apply some 6 months later and tell me be satisfied with being applied in October.
Well, I can tell you. Go ahead.
Sorry, the thing is, which should be done is, if you intend to do such a thing, you should write a letter attach your payment to it so that it's put on file and it's clearly visible for all to know that this is what your intention is. And that is something, sometimes transactions are done on the back end by the finance department that cannot be done on the front end, for instance, at the cashier level. So, or even at the loan officer level, the loan officer may put in a request for certain things. So if you would have written a letter to your loan officer and said, this is what I want to do, here's my check, then that loan officer could go ahead and execute it through the proper channeling and make sure that it's done in the way that you intend. But I understand what you're saying and I understand your point. And it's just unfortunate that, everybody isn't always on the same page. And even in an organization, like you have different links of people, different arms going on, everybody's doing whatever they're doing. So you can imagine the poor cashier, she probably had another 20 people standing behind you that she had to service. So she was not going to be in a position to break off to the receptionist or to whoever else and say, hey, I just got, a lump sum payment for this person. They want it all applied to principal, make sure that this happens. By the time she would get around to that, that's at the end of the day. And, something could get lost in translation too. So I understand what you're saying, but yeah.
Yeah. I would say, the best thing to do is, like she said, you have to sit down with the finance officer, not the loan officer.
Can I chime in?
Yes, go ahead.
For me, not necessarily, like she's saying, I know with us at RBC and RBC FinCo, once you add the tellers and you let them know you want to make a principal payment, they can do that transaction for you right away. And we even have one where you can leave post-dated check to have principal payment applied on specific date, or you can have a standing order set up for a certain amount to go to your principal on every day of the month, as long as not on the day as your regular blended payment. So I hearing what the other people are saying, and I have to agree with Mr. Johnson, there's just simply no excuse. And even say, for instance, if you present yourself to a teller and they forget to make their principal payment and the money is sitting there in their account, and when the clients come in and that's recognized, we normally backdate that principal payment to the date it was deposited to the savings account.
Yeah, that's the point I was going to make. That was the point I was going to make, because I know in my previous employer that, like how Mr. Johnson has that issue, the actual finance department, or the credit department, they would actually manually calculate that mortgage and put those interest payments on the actual date when it should have been applied.
Exactly.
That is what they. Yeah.
But Mr. Johnson, as I said, put it in writing so that there's that's your information to use for later, that say, I clearly stated X, Y, and Z. And I agree with, I can't remember who was speaking earlier. I agree with you. Yes, the cashier should be able to do certain things and whatnot. But I, as a client of other organizations, have been experiencing some crazy things, and what seems like common sense isn't what generally happens. And so I have learned, as a normal client going here and going there, that put it in writing, make sure it's properly documented from your side of it, so that if there's any sort of failure for that to happen, that you have something to fall back on. Because looking at these case studies, you can see the reason why I'm saying that too. Clearly, that would help you not to have a lot of the aggravation that you could end up with, like what you're experiencing right now too.
Yeah, I agree. But a lot of it turns to, again, as bankers, you really have to understand what your duties are and what it entails in being a banker. Because a lot of people do things by route, not understanding why they do what they do and how important it is to the client. Remember, as we said in the first two classes, when someone actually goes to a bank and they apply for a loan, for a mortgage. That is that person's investment. And at the end of the day, after you've paid almost 15 to 20 years, to come to find out that your balance is not correct, or that the bank is actually gone and they actually now have your house up for sale. It is really disheartening. And it's hard on some people to even accept it. And so as bankers, I know you say you ask the client to read the fine print, but realize sometimes people can read it and still don't understand what it means. And it makes it difficult, because the first thing they're going to tell you is, I don't remember reading that, or I didn't know that's what that meant, but then it's too late. So once the loan is repaid, then the borrower has redeemed its property. Now, you always remember, there must be no clutter or impediment on the equity of redemption. So in equity, the property belongs to the borrower, and the purpose of the mortgage is to provide a security for repayment of the loan. The borrower ought to be able to get his property back by paying off the loan with his property in the original condition. The borrower should not place undue postponement of redemption. Note that the parties may agree to a long-term repayment, and early repayment might put the lender at a serious disadvantage. And that's what we just discussed, because they have already calculated that interest for 30 years, 25 years, 20 years. Now, remember, there is protection and there's perfection of the security mortgage interest. And that's against any third party. So in addition to that protection that's by law, which means that you have to record or file the mortgage documents and produce evidence of stamp duty, a security interest which is unrecorded or filed in the absence of that statutory provision may be perfected vis-a-vis a particular third party by giving notice to that party or knowledge on their part. An accurate and thorough title search of the particular property being mortgaged or used as security for a mortgage will assist any third party purchaser or creditor in discovering the existence of an adverse title or security interest. And we did adverse title last night. Whether created by the seller, the debtor, or by one of his predecessors in title. The object of the filing or lodging of the mortgage document and other documents of title is to give notice of the security interest to third parties. Failure to file or lodge the relevant mortgage document does not, in principle, affect the enforceability of the security as against the debtor himself. The time of filing of the document of security interest is of utmost importance in terms of the priority of interest of the secured creditor. Note that in terms of the priority of security interest, particularly as it relates to the mortgagee in the Bahamas, the first document to be recorded in time prevails. Failure to file or lodge a security interest, whether a mortgage or a judgment order from the courts, will result in the fact that secured creditor is postponed to subsequent incumbencer and loses out altogether to an outright purchaser, particularly a bona fide purchaser for value with no knowledge of the prior security and who is not involved in any fraud or collusion regarding the same. So where mortgage property is a debt or other money owing as the person to whom the notice should be given, a mortgagee who gives written notice to the debtor gains priority over a mortgagee earlier in date who omits to give notice. The omission to give effective notice leaves the property under the mortgage's control and deprives the second mortgagee of the chance of ascertaining the existence of the first mortgage by inquiry of the debtor. The filing of the relevant mortgage is important to the notice requirement and to protect the interests of the first mortgagee, because the priority of the second mortgagee does not depend on whether it made inquiry. It depends solely on notice. A judgment creditor who obtains a charging or similar order from the court will be treated as a volunteer and cannot gain priority by giving notice. Note that where notices are contemporaneous, the encumbrances will rank in order of the time of creation. So as you all are aware, real property tax represent a first charge over property. And this arises automatically by operation of law. It doesn't require any filing or lodging. So what happens now when it comes to the borrower being unable to pay? The bank has remedies. So the first thing is they can bring an action for debt. The bank, as a mortgagee, has a right to sue.
I'm not hearing anything. Is that just on my end?
No, I don't hear anything either.
Okay.
Same here.
I'm not hearing anything either.
She looks like she muted her.
No, it dropped.
Oh,
Yeah, it dropped. So I had to switch to mobile. Okay, you got the part about remedies?
you could
The
say it
first
again.
action, remedies. When the borrower is in default, the first action that a bank can take is to actually sue on the debt independently of the security. But there are other rights that they have that are more extensive. The second one is they can enter into possession. And this is by court order. If the mortgagor is in occupation of the mortgaged property, the eviction order is needed. The costs to enter into possession are borne by the mortgagee. And entering into possession is normally one of the initial steps in selling the mortgage property. So there are a number of restrictions on the bank being able to enter into possession. If the mortgage property is a dwelling house, then the court has a discretion to adjourn the action if the mortgagor is likely to be able, within a reasonable period, to pay the sums due. So in the case of Cornell versus Maltby, it suggests that there may be a general discretion in the court to refuse possession to a mortgagee if possession is not sought for the purpose of security, but for an ulterior purpose. The second remedy that the borrower has is he can appoint a receiver. And this normally is for mortgage property that is leased to tenants. The receiver appointed by the mortgagee is paid rent directly by the tenants of the property, rather than paying the rent to the mortgagor, who is the landlord. And this is an attractive remedy only if the bank wishes to continue with the mortgage and the land is income producing. However, before the bank or the mortgagee appoints a receiver, it has to make formal demands for repayment from the mortgagee. And there are extensive cases setting out the duties of a receiver. So although the receiver is appointed as an agent of the mortgagor, he must take steps to protect and preserve the mortgage property. When it comes to selling the property, they owe the same duties to the mortgagor and others interested in the equity of redemption. This means that although they must obtain the best price reasonably obtainable, they are not obliged to take steps to enhance the value of the property or to delay a sale in order to achieve a higher price. The remedies of entry into possession and the appointment of a receiver do not bring the mortgage to an end. So the fourth one is you can have the sale of the property. And that is where the bank goes in for the power of sale. So the act gives the mortgagee a statutory power of sale. Once it becomes clear that the mortgagor is likely to remain in default of his obligations. So banks normally seek the remedy in conjunction with obtaining vacant possession. So under the terms of the mortgage loan, the mortgagee has a power of sale to sell the mortgage property in the event that the mortgagor defaults, even where the property is still occupied by the mortgagor, subject to obtaining an eviction order for eviction and following other legal formalities. So if we look back, that's 4, 5, 6 years ago, when a lot of homeowners were in default. What did the banks do? Package it and sold it, because they were not in the business of managing properties. So a mortgagee is not a trustee of the power of sale for the mortgagor. He has an unfettered discretion to sell when he likes to achieve repayment of the debt which he is owed. So a lot of the borrowers were screaming that the bank should not have sold or put their properties up for sale. But the bank has that power under the act. So the mortgagee need only have regard to his own interests and need not postpone the sale in the hope of obtaining a higher price or take steps to achieve a higher price. The mortgagee's only duty is preserving the value of the security and to obtain the best price that can reasonably be attained. So if the mortgagee exercises his power of sale and there are surplus funds or proceeds from the sale, then it goes to the mortgagee. On the realization of a security or the exercise of a power of sale, the bank must act reasonably and obtain a fair price for the mortgage property that is sold under power of sale. So in the case of Standard Chartered Bank versus Walker and Walker, a company issued to the bank a debenture, giving the bank a charge over the company's assets in respect of any sums then or in future owing to the bank. The debenture empowered the bank to appoint a receiver with a provision that any receiver so appointed was to be deemed the company's agent, and the company alone would be responsible for his acts or defaults. So in November 1980, the bank appointed a receiver who engaged auctioneers to hold a sale of the company's stock As the auction was held on a cold day in February, the proceeds of sale were entirely absorbed by the expenses of realization and preferential debts, other than that of the bank. The bank claimed the sums guaranteed by the client, and the client subsequently brought an action against the bank, alleging the sale was poorly organized and realized at a gross undervalue. The court held that a receiver realizing assets under the debenture owed a duty both to the borrower and to a guarantor of the debt to take reasonable care to obtain the best price that circumstances permitted, and that a duty was also owed to exercise reasonable care in choosing the time for the sale. Despite the receiver being deemed the company's agent, the bank, as holder of the debenture, might have responsibility for the receiver's actions if it was shown that it interfered with the conduct of the receivership. As these were tribal issues, the borrower would be granted unconditional leave to defend. Similarly, an appraiser or surveyor who negligently values a house for mortgage purposes so that its for sale value is less than the amount loaned by the mortgagee to the mortgagor will be liable to pay damages for the mortgagee's entire loss, including any unpaid interest at the default rate in the mortgage loan. The timing for the realization of the security or exercise of the power of sale after the default is entirely a matter for the bank. The bank is not liable to the mortgagor or surety for a decline in the value of the mortgage property, unless the bank was responsible for that decline. So in the case of China and South Sea Bank versus Tan Son Jin, the decision of the court was that a mortgagee's decision on sale is not constrained by reason of the court. Decision of the court was that a mortgagee's decision on sale is not constrained by reason of the fact that the exercise or non-exercise of the power will occasion he can sit back and do nothing. He is not obliged to take steps to realize his security. Where creditor leads against the debtor, a security and a surety, it is a matter for him which one he pursues, if indeed he pursues any at all. Then I also gave you the case of Chart Enterprises versus Royal Bank of Scotland PLC. Note that a court has the power to order the sale of mortgage property, even though a mortgagee may refuse consent to the sale, because the sale would realize insufficient funds to pay off the money advanced by the bank for the mortgage loan. In the case of Bulk versus Mortgage Services Funding, the court ordered that the sale sought by the mortgagor, refusing to let the mortgagee retain the property and rent it out. The value of the property was insufficient to cover the loan, and the rent would not cover the interest payable, with the result that the mortgagor's liability would increase if the mortgagee remained in possession, unless property values increased steeply. In the decision of Target Home Loans versus Clothier, the bank may allow a mortgagor the opportunity to try to sell the mortgage property, as the court held a view that there may be instances where an occupied property is more attractive than a repossessed property. And I know a lot of the clients, before they had the bulk sale, made this point, that if they remained in the house, it would have been better in terms of getting a good resale value than having the house unoccupied, and then the houses began to run down. The terms of the sale of the mortgage property by the mortgagor already in default may also be agreed that after the end of a certain period of time, for example, 3 months, and no sale was made of the property, the mortgagee could take immediate possession of the property subject to the legal formalities and exercise its power of sale. A bank in exercising its power of sale has no duty towards a beneficiary of a trust, where the mortgagor is a trustee of the trust or mortgage property. And the last remedy that a bank has is foreclosure. And that's under a court order. And that has to be obtained by the mortgagee, and ownership of the property is transferred from the mortgagor to the mortgagee. Any questions? Because I think you all are familiar with these remedies now going through the cases. So let's look at McKinney and Bahamas Development Bank and Roosevelt Butler and Kim Roll. I know you have that one. I just sent it. And this one pertains to the sale of a home and whether they obtain the best price. The name of the second defendant is incorrect. On the cover page, it says Butler, but his name is Butterfield. So at paragraph 10, it says the bank also averts that its power of sale was validly exercised in all the prevailing circumstances. And the bank denies that it wrongfully sold the said premises and that it sold the said premises for a price less than its market value. Because that is what they were actually saying, that it was sold for less. So if you look at paragraph 16, it gives you clause 610 of the mortgage deed. It gave the bank the power to sell the property upon default. So this is what the plaintiff is alleging. The plaintiff said at paragraph 20, at trial, the plaintiff withdrew the allegations of fraud and collusion and also the claim to set aside the sale. In his opening speech, Mr. Winder stated that the plaintiff's claim concerned the exercise of the bank's power of sale against the mortgage property, whereby the bank sold the mortgage property to the second defendant and the third defendant, who at the time of the sale and purchase were tenants of the plaintiff, making monthly payment to the bank on behalf of the plaintiff. Understand the arrangement now? The bank sold the property to the tenants of the borrower.
So the tenants would be the receiver.
Made a formal demand for the outstanding mortgage payments or giving the plaintiff notice of the sale. Because the plaintiff had left Nassau. He was living on the family island. So they were sending notices to him, but not at the address that he was at. So at paragraph 25, the plaintiff said that in early 1990s, he rented the mortgage premises to the second and third defendant at a monthly rate of $2,500. He stated that the bank agreed to receive the rent from his tenants and apply the same to his mortgage account. He further stated that the bank also agreed to inform him should there be any default in payments. The plaintiff confirmed this evidence in cross-examination. His viva voce evidence was that he and Andrew Sanford discussed the arrangement by telephone. And Sanford told him that he would be at the mortgage property each month to collect the rent from the defendants. Because he also said that Mr. Sanford never told him that the loan was in arrears. He said he received a letter dated the 12th of July 1995 from the bank advising that due to arrears in the loan account and that the bank had accepted an offer to purchase the mortgage premises. He said he never received any letters from the bank advising that his account was in arrears or that the bank intended to exercise its power of sale over the mortgage premises. He said he had informed the bank of his move to Acklands in 1991 or 1992, and that he did not recall receiving any letters from the bank in Acklands or at any of his or other business places in New Providence. He stated that the mortgage premises was sold, paragraph 27, without the bank giving him the opportunity to either bring his account current or to secure a higher offer to purchase. He thought the mortgage property was valued at about $750,000, but he did not have the building appraised by a professional real estate appraiser. Let me go to my highlighted sections. The bank was unable to approve service of the demand letters. And they said the issue is not whether or not he knew he was in default of the mortgage, but whether or not he was given sufficient time in which to redeem the mortgage. The cornerstone of a mortgage is the mortgage's right to redeem. In the instant case, the plaintiff and the bank agreed that the plaintiff would have 30 days after demand for payment has been made in which to redeem the mortgage, because that was the clause in the actual mortgage deed. Section 22 of the CLPA provides that the mortgagee's power of sale should not be exercisable until demand has been made and the mortgagor has made default in repaying the mortgage for certain defined periods of time. However, by Section 21 of the CPLA, the parties may vary the statutory period in any manner. In this case, by clause 10 of the mortgage deed, the parties agreed that Section 22 of the CPLA shall be varied, and that the statutory power of the said shall be as between the lender and a purchaser from the lender be exercisable at any time after the execution of the security, provided that the lender shall not exercise the said power of sale until the payment of the monies hereby secured have been demanded and the borrower has defaulted for 1 month in paying the same. See why it's so important to actually read the mortgage deed. So the bank said that they advertised the property in the Guardian, but in court, they were not able to produce a copy of the notice. So the only other evidence that the bank gave that they got the true market value of the mortgage property is that the bank approached the defendants and requested them to put in a bid for the property. So Butterfield and Roll gave evidence that the bank initially approached them to purchase the property for $750,000, which is the valuation the plaintiff placed on the property. They declined to do so. So the question is, why did the bank first approach the defendants with an offer of $750,000? The outstanding balance was far less than that amount. The defendant's counteroffer was in the amount of $180,000. And then $220,000, which was accepted by the bank. That approach by the bank does fall outside the category of reasonable steps to obtain the true market value of the property. Don't you smell a rat in that whole arrangement?
Yes. How many pages does this document have? Because the one I'm looking at, I don't think it's the same thing that you're reading from. I only have 7 pages and it goes up to number 19.
No, it should go up to 77.
Okay, so I don't have that, whatever you were reading.
You don't have this? Hold on. And what I sent?
I looked at what you did send and opened up the ones that you sent. And I don't know.
Hold on, let me go back to this.
This is Mackie. I don't have that either. Mine goes to page 7 as well.
Well, what's wrong with this? Hold on.
Because it says Lawrence McKinney, Bahamas Development Bank, Roosevelt, Butler, and Kimbrough.
Yeah, that's it.
But it only has 7 pages.
7.
You still only have 7?
Yeah.
Yes.
Okay, hold on. Let me look at this. 1997. Yeah, I see this one only has 7. Hold on. Oh, I sent you the wrong one. Well, but hold on. What did they do? Well, let me see what my computer did. Yes, it's the same people. And it's from the Supreme Court.
Yes,
Yeah,
but
but-
Ms. Asha, I think the one that you sent with 7 pages was looking at what channel was on the premises when
Yeah,
it,
I need the one I want though. I want this one here. What has to do with the valuation of the property?
right. So I don't think I have that either.
Okay, hold on. Because I went to the site and pulled it up. But it is not. Why isn't it coming up? But they say it's actually Butterfield. Let me see if it comes up. Case number 245. No, this is case number 624. Let me see something. Yeah, because this judgment is done by Justice Claire Hepburn. And I don't know why it's not coming up. It's coming up, but this one isn't coming up. The one that I'm reading now, this one isn't coming up. Give me 1 second. Let me see if I can get it up. Okay, commercial. $2016. Let me try this. No. Gotcha. I gotcha. 21 pages. Hold on. Yes, got it. I'll be sending it to you right now. Let me give it a different name. Okay. Okay, give me 2 seconds. I'm about to send it to you. Okay, let me go here. Apply to all. Bar. Kristen. Dihana. Keishala. Simmons, Monique. Delete. Okay, you should have it now. Let me know when you receive it.
Received, that's the 21-page document, correct?
Yes, yes, you have it.
Okay. Yes, ma'am.
Steve, thank you very much.
Okay,
I received it. Thank you.
okay.
I'm also in receipt. Thank you.
Good. All right.
Hello?
Yes.
Oh, okay, sorry. I thought my internet ran out again.
No, it's fine. I know this is pages, so I'm giving you time to read and then let's discuss what happened.
Okay.
It's kind of long because there's some key things in here. Paragraph 16 and 17. These are two clauses in the mortgage deed, and they are in conflict. That's paragraph 16 and 17. So the plaintiff said that the value of the property was $750,000, but he couldn't provide any evidence of that. So what the bank did was the bank sold the property for $220,000 to his tenants, rented the property from him at $2,500 a month, but they stopped paying the rent on July the 17th, 1995. And then they purchased the property 10 months later. So in that 10 months, they didn't pay any rent. At all to the landlord. So the court ruled that even though they had sent the bank claimed that they had sent the letters, he said that he'd never received it. And if you look at the value at which they sold the house for, the property for, the court ruled that the bank improperly exercised the power of sale when it sold the mortgage property for the sum of $220,000. And therefore, if they use the median between the two prices that were quoted, the bank owed the plaintiff $85,400. The other two defendants also owed the plaintiff the rent due for that 10 months. And they also owed him money for the furniture or the equipment that they destroyed in the 7-page case that you read. Still reading?
Ms. Archer,
Yes.
how come? Okay, the defendant said that this property was worth 700 and something thousand, right?
Mhm.
The bank turned around and sold it to someone else for 220,000.
Sold it to his tenant.
Yeah, so shouldn't an appraisal or something should have been done?
Yes.
Or shouldn't an appraisal should have been on the books, on the file to say how much this property is worth before the bank just sell it for $220,000?
Yes.
Is that legal?
Oh, no, it is not. That is why, well, see, the thing about it is that the bank claimed that they did some advertising, but they couldn't provide any evidence that they did it. And the bank said that all the advertisement is, it just says that you advertised it. But they had two reports. Where is it? They have what's called, they have the name of it. With two different valuations. Let me see if I can find that paragraph. Where they gave the valuation of the properties. I normally have it circled.
I think there's many rats afoot in this story. First of all, why would the bank entertain the tenants who promised to pay rent to the bank for the borrower? But
Now,
they
stop right there. The
failed to
bank
do
said
that.
that business. The bank said they would have never agreed to that. They're not in that business. Okay, let's go back to the 750. They say he couldn't show how he arrived at his valuation. So Mr. Amali, he gave a method of valuation. And his valuation, according to his figure, the property was $305,000. Paragraph 66. And you'll see where the court came up with a difference of 85,400. The Ferguson Report. The bank asked the court to adopt the Amali Report. The Amali Report had the property appraised at $305,400. The plaintiff instead said the valuation was $750,000. And he got that from the Ferguson Report. But Mr. Ferguson was deceased at the time of the trial. So the court went instead with the Amali Report, saying that the valuation was at $305,400. And then they sold it for $220,000.
That's a big gap.
Yes.
That don't even make no sense. So that.
But see, when I read this, I'm saying I have rental property, right? Irregardless of the arrangements that he claimed he made, because he still had someone in Nassau who was making sure that the rent was paid.
And the rent was paid.
So all along, the rent was being paid. Now, I don't understand how the tenants then decided that they're not going to pay.
Because them and the loan officer don't make a deal.
That's what it looks to me.
Yeah. Because all of a sudden, how could you just not pay? And then next thing you know, you own the property?
Yes.
Some fishy business going on there. And then there's one report that says that this property is worth 750,000. Then there's another report that says that this property is worth 350,000. And
Mhm.
the gap is too wide. It isn't even on the same level, or even say 600,000 or something like that.
And the
That's
thing is,
like half of what the property is worth.
right, then the court went with the one with the report where the figure is the lowest because the person who prepared that report is still alive. I think they should have just asked for an independent one
Exactly.
to
I
get the
was
truth.
just gonna say,
What is
Because
interesting is
said the gap is
in
too
the
wide.
what is interesting is that in the other one that you sent us by mistake, it seems they also damaged the property. It's strange that they would damage property that they had interest in buying as well, which in maybe they damaged the property to deter other people who might have been interested from purchasing or offering a higher amount.
Yeah. Mhm.
yeah.
And they had to pay for that. The defendants had to pay for that to the plaintiff for the property that they damaged. The table and the chairs, the boots, the freezers, refrigerator, screens, carpet. This is a lot of things.
And then we destroyed everything.
Mm-hmm.
They had to sell everything. They sold everything.
So I'm wondering if they did that also to devalue the property.
Maybe they did. So that it could be a better chance of them getting it.
Yes. So this was a furnished apartment and they damaged all of this property. But
And then
they
there's in 72,
right.
there is also evidence to support that the claims that the repairs were made to the mortgage.
Now notice they also claim in paragraph 65 that there were vermin infested and they had no worth. So what vermin infest a refrigerator and a freezer, an air condition, and deep fat fryers?
Mhm.
No. Yeah, the court ruled that they had to pay for that. So there's quite a few key things in here. One, you must read the mortgage deed. Paragraphs 16 and 17, and then to the judge's decision in paragraph 63, speak to these two clauses and how they conflict with each other. And remember, I always say the bank is seen as a professional and they're supposed to exercise the skill and care of a professional. And the bank construed the clause against the bank. The court construed the clause against the bank, saying that they didn't give the plaintiff notice. And then the next issue was, what was the value of the property? Did they get the correct appraisal amount? Yes, the court went with what was presented before them. Because the plaintiff couldn't substantiate his 750, because the appraiser who did that 750 was deceased, the court then went with the other report that was done by the bank. So what he should have done, knowing that the appraiser was deceased, his counsel should have advised him to get a fresh appraisal. So I think in this end, he lost.
Yes, he did.
He lost a lot. Because if this was valued at 750 before all of this destruction, he's lost a lot of money.
He lost a lot of money. Yeah, because they only bought it for what, 220,000 or something like that,
220,000.
from 750.
Mm-hmm.
But why even would the judge rule on a situation like that without all of the facts and all of the systems
But
in place?
it's right. But see, it was up to the plaintiff. It was up to the plaintiff to present his
Okay,
case with the actual value of the property.
of the property, but he didn't.
Right. No, he only gotten that one from the deceased appraiser.
Yeah,
He should have presented, this is what the deceased man did, and this is what the property is appraised to
and this
right
is what it, yes,
now. Right, bearing in mind the property that was destroyed.
yes.
And if he could have gotten some furniture appraiser to say this was the value of those properties at the time,
At the time,
before the destruction, and also based on their use, he would have stood a
yes,
better chance of more money. But this case was not properly prepared because he wasn't able to find in terms of getting the true value of his property. And notice he only borrowed $58,000. That's all he borrowed. And he lost. Now that's a little sad one for the night. I'm sorry. I didn't mean it to be so sad. But it is what it is. Okay,
just
so
goes to show you that anything can
Huh?
happen, and anything that you are, it just goes to show you that anything can happen. Especially
Yeah.
when you're paying a mortgage and you have people living in your place, in your home, and you trust them to pay you and do the right thing, and next thing you know, they're on the other side trying to take your place from you.
of course. Of course.
But like you said too, it's always good to read your mortgage carefully and read your clauses and see where it benefits you at the end of the day.
Mm-hmm. And a lot of people don't read it.
No, Miss Archer, because they just want a mortgage. And then when it comes down to it and they find out that all of these clauses are in your mortgage and there are certain situations that you have to deal with when it comes to your mortgage and paying it on time and your late fees and you get a grace period. And they don't, when you tell them these things, they hear you, but they're hearing you. Because at the end of the day, when it happens, then they say, well, you never told me this or you never told me that. But it's in your mortgage agreement,
Yeah, and they don't read it.
you know?
So have you had the opportunity to apply the Homeowners Protection Act in any situation before you go into entering the power of sale? Whereby any family member of the borrower makes contribution towards the mortgage, they could approach the court for relief so that the bank doesn't enforce its security. I haven't found any recent cases except the one that we mentioned, where it said that the Homeowners Protection Act kicked in terms of the power of sale. But there haven't been any cases yet, not that I've seen. I've checked the websites. I haven't seen any that actually refer directly to the Homeowners Protection Act. Anybody have any first-hand experience? No, yes. If you look at paragraph at clause 15 of the act, it says that the mortgagor may, not more than twice in a year, request in writing to the mortgagee to furnish him, without any charge, a statement in writing, setting out with respect to the mortgage, the amount of principal, interest, and any other costs and fees owing. So you have that in the act itself. And the mortgagee shall respond within 30 days of receipt and without reasonable excuse if they fail to do so. Any rights that he may have for the enforcement of the debt or mortgage or for the cancellation or specific performance of its term shall be suspended until he has complied with that request. And the mortgagee cannot charge no fees for providing a statement to his client. And the mortgagor can choose the attorney and the appraiser for the mortgage transaction. The mortgagee shall publish on his website a list of the approved attorneys along with the criteria for the inclusion on that list. And the mortgagor is not required to pay for the cost of any attorney other than his own in a mortgage origination or for the modification. And if a mortgagor under section 17 of the CLPA wants to transfer his mortgage, he can do so. So what are your views on this Homeowners Protection Act? Does it change anything? Does it make it easier? Is it more advantageous to the borrower? Because I mean, the banks already had the procedures in place whereby they would sit down and have a discussion as to how they could restructure the debt. I guess it's just a point whereby there's more time, the court grants more time for the mortgagee to make arrangements with the mortgagor in terms of delaying the process.
I think courts already take a lenient stance with mortgagers and will give adjournment after an adjournment in order to give the mortgager an opportunity to refinance or to reach some agreement with the lending institution. So I don't know if it really provides a mortgager with any greater extent of relief that already existed, but I guess it puts it in black and white.
It puts it in black and white, yeah, and gives the time period. And then it also provides for, like I say, other members of the family or other persons contributing towards the payment of the mortgage. It gives them some right to go before the court in trying to have this whole, the bank executing its power of sale. But I mean, everything in here seems to be what the bank does now. They
Agreed.
always sit down with the client to talk about restructuring. They always give the client notice. And in many instances, sometimes the bank owed 3, 4, 5 months, and the bank would sit down and try to restructure and give them an opportunity to pay. The mortgagee's duty of fair dealing. I mean, a lot of these things that are in here are all a part of the common law principles to deal with mortgages. Section 11, Section 2 says, a mortgagee shall disclose in a notice that in exercising its power of sale, the mortgage property may be sold at less than the market value. And in the event that the property is sold at less than the market value, the mortgagee may pursue the mortgagor for the recovery of any sums. That's already there in common law. If you sell the property for less, then of course, the mortgagor has to pay, the mortgagee has to pay. The mortgagor has to pay the difference. I think the only thing it does is it give you a little bit more, the mortgagor has little more rights in terms of filings of notices, in terms of when the bank takes certain steps. So if you take in that same Section 11, subsection 5, it says prior to the mortgagee accepting an offer to purchase the mortgage property under the act, the section, the mortgagor may make an offer to purchase the said mortgage property at the market rate. I don't understand that one. I have 2 question marks there. So before the bank will accept an offer to purchase the mortgage property, the mortgagor may make an offer to purchase the said property. But he's already in default. So what do you mean he's going to another bank? Doesn't it sound like?
Yeah, I think that's what that means. If that person can get financing somehow through another banking institution and move the mortgage, the bank would allow it because all they want is to be paid and have their mortgage satisfied. So it's an easier sale if the buyer just moves the mortgage rather than for them to go out, headhunting to find another buyer.
So it says the mortgagee shall at its option accept the highest price offered for the sale of the mortgage property, even if the price is less than the market value, and shall on receipt of the proceeds of such sale apply the same to the sums due and owing under the mortgage. But of course, under the common law principles, they have to make sure that they get fair market value. Because they said accepts the highest price, but it has to be fair market value. And then it says that if you sell the house for a higher amount, of course, the mortgagee shall pay the remaining balance to the mortgagor or to their heirs.
Isn't that where the proof of advertisement comes in? Because if the banking institution can prove that they've advertised the home several times, and then they can show that, okay, we did accept an offer that's less than market value, but it's the best of all the offers we've gotten over said period of time after so many advertisements, then,
Yes, because don't forget now, when the bank makes a decision when it wants to sell. That's the bank's
Right.
decision. But once they make that decision, then they go ahead and they sell the property.
And depreciation can have some part to play in that as well.
Mhm.
Because even then they realize too that if the house has been laying dormant for a certain amount of time, it's gonna become at some point, less and less in value, and then, less chances of them selling it for the pricing that they would like to have for it.
Yeah. Now, the good thing about this piece of legislation is Section 12. And as Section 12 prohibits related parties, the mortgagee exercising his power of sale to related parties. So they can't sell the properties to any employee or director or any immediate family of those persons. They can't sell it to the spouse or the children or the parents or the brother or sister or cousins. Now that part is good, because that's used to be the complaints of a lot of customers, that the properties were sold to relatives of the bank's employees. And of course, the right to request your bank statements. And other than that, I think that's about it. Yep, that's about it. Nothing else fantastic about it. It's just that part there. All right, so on Monday, we will go to Unit 5, and we're gonna talk about the mortgagor's duties, liabilities, and rights. I'll see if I can find some more cases. Not getting bored with the cases as yet, right?
No, they're very interesting, actually.
Okay, so I'll see if I can find some more, and I could send them earlier so you could read them prior to coming to class, okay? I will do my endeavor best. All right, any questions? Sounds like it's a no.
No, ma'am.
All right, so enjoy the rest of your weekend. If you wish to, you can sit down and read your cases again. Think about some things that you probably may wish to recommend to your institution. Looking at the mistakes that have happened in others. It's a good learning point to get started with. Looking at how you can address some of these things that happen. Okay? All right, so I will speak to you all on Monday. Okay?
Good night.
All right,
Okay,
good night.
good night.
Bye.
Good evening.
Good night.
Good evening.
Thanks so much.
Yes, good evening.